Papa Father, cover this meeting and all that are shared today and protect us from evil. And we thank you for the opportunity for freedom and liberty. And in your name we pray. Amen.
Amen.
And now, the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay.
Very good.
Play ball. Okay.
Thank you. Now, without any further ado, we're going to go straight into today's subject matter, and it has to do with child custody and courts. And Robert Dean is going to give us an overview of what we can and can't say publicly today.
Thank you, Dr. Duke. We have this past Monday in the Circuit Court of Norfolk, Virginia, there was a custody case which I attended, and it was very alarming. I couldn't believe my ears when I heard the judge's comments. We will not name his name, but it was this gentleman that he and his wife had 3 children, and there was no charges against him for anything at all, nothing. And over the last 420 days, he was only able to see his children 9 days out of 420. It's a horrible situation. So he went to court, and this judge leaned heavily towards his ex-wife and the children. And some of the situations that arose in this case was he went to visit his children and took his mother, which is their grandmother, for a birthday for one of the children. And when they went to open up, she wanted to videotape the child opening up the birthday presents. She brought charges against him that he couldn't ever do any videotaping at all of the children, nor his mother couldn't be their grandmother. It went on and on and on. So the defendant in this case is with us this morning, and but he's got a couple of attorneys representing him, one from North Carolina, one from Denver, Colorado, which his name is Stanley Thorne. He is, I think he's known as Cowboy Thorne out there. And so he is a very successful attorney, and he's representing Joe Sherman on this case. And I apologize for the video, the clarity this morning on this new substitute projector. So at this point in time, I would like everybody to introduce everybody to Stanley Thorne from Denver, Colorado.
Is that my handoff?
Yes. Yeah.
Well, I want to thank you for the opportunity to speak to this group. It is an honor to be associated with both Joe Sherman, the father that's involved in this case, and his attorney, Jeremy Hopkins. Jeremy is the attorney from North Carolina. I actually am a Texas licensed attorney of 42 years, but I live in the Denver area. Can you still hear me okay?
Yes. Can you?
Okay. I think what I would like to do is give an overview of this case, but in order for you to appreciate what's happening to Joe Sherman and his 3 children,
Go ahead.
in order for you to appreciate what's happening to Joe Sherman and his 3 children, I want to give you some historical context by beginning to tell you what's happening to Joe Sherman is not atypical. The facts of this case, no one who's got a sense of justice, which is simply about fair dealings and being treated fairly, no one with any balanced sense of justice would consider this process that he's been through, which is basically a sausage brownie designed to destroy a parent. One would consider what's happened to Joe to be fair or just. But going back into the 60s, before the era of no-fault divorce, in order to be divorced with children, you had to prove that one party or the other was at fault. That goes back to two things to which we owe a great debt to the people of Great Britain. That is, that they gave us principles from Magna Carta, and they gave us the common law. And from those principles, we have this sense of justice and what all legal remedies in the United States, in the American system of justice, always depend upon proof to a reasonably sufficient evidentiary standard that there is some sort of harm or fault or breach by one party for which the law can give the remedy to the other party. Fault divorce was brought into the United States from Bolshevik Russia in the 1960s. It is antithetical to everything about the American system of justice. It basically says you don't have to prove fault on the part of either party. One of the principles that drove the adoption of no-fault divorce across America, I have a recorded audio of him being interviewed saying he knew it would result in what's become unilateral divorce on demand. What happened when they implemented no-fault divorce in the 60s is shifted the battleground from the divorce action to child custody. That was a Bolshevik intention in order to destroy the family. What the Bolsheviks wanted to do in the Russian Revolution is to destroy the church and the family, because those are the two institutions in our society through which the values are passed from one generation to the next. It was an absolutely intentional thing when the Bolsheviks created what they referred to as postcard divorce. Postcard divorce was just a clerical process. It didn't even involve their courts. If you wanted to divorce your spouse, you just went down to a ministerial office. If you wanted a divorce, you filled out some paperwork and a postcard, and the postcard was mailed by the clerk to your spouse to notify them that they were divorced. It was so destructive to the society in Russia that after 40 years, in the 1960s, they were in the process of abandoning it. About the time that a group of useful idiots known as the National Council of Commissioners on Uniform State Laws decided to promote no-fault divorce in America. The objective in America was exactly the same as it was in Bolshevik Russia. Destroy the family. Destroy the parent-child relationship so that it's not a basis upon which values should be passed from one generation to the next. Because at the time no-fault divorce was implemented for the first time in California, and then within 10 years, 35 states had adopted it as we went into the 1970s, the divorce rate went from 300,000 a year in America to over 1 million a year. Ever since then, about 1 million divorces a year occur, coincidentally affect about 1 million children, 1 million minor children each year. What's become of our judicial system and our family courts is a massive wealth transfer mechanism, because they have weaponized children and monetized children. They are now the basis for enormous wealth transfer from the non-custodial parent to the custodial parent. And the more lopsided the time is, the system is designed to maximize the amount of child support paid as long as the amount of time with one parent is minimized. Now, all that may not make a whole lot of sense, but what they've designed is a system that is monetized to children, because the state of Virginia gets to keep a percentage of all that child support money that's being transferred from the non-custodial parent to the custodial parent. I'm told that last year, and these are public records available on the state of Virginia's Health and Human Services website. I'm told that last year, what the state of Virginia got to keep is $1 billion. $1 billion for child support money was kept by the state of Virginia based upon the total amount of child support flowing through the system. What's happening to Joe Sherman is the same financial incentive, which is a perverse one, which says that the less time Joe gets with his 3 children, the more child support he pays. because he pays more child support. If you spread that across the whole system, it's across Virginia. The less time they have with their children, the more child support they pay, the more child support money the state of Virginia gets to keep. There's this enormous financial incentive to keep the system the way it is. Yesterday, as a result of the way Joe Sherman has been treated over the last year in Norfolk County Circuit Court and Accomack Juvenile and Domestic Relations Court, filed a petition under the original jurisdiction of the Supreme Court of Virginia, in which Joe Sherman represents himself as a petitioner because he's a successful local attorney, and Jeremy Hopkins, the North Carolina attorney, who knows Joe and is working with Joe on a pro bono basis. They are friends from past experience, and they both worked at the same Virginia law firm together before Jeremy moved to North Carolina. Jeremy and I know each other from past experience working on cases together, because for about 15 years I campaigned across America to try to do family law reform using the U.S. and state constitutions. And what I learned after 15 years of serious campaigning is that judges, all judges virtually across the country are attorneys, and all attorneys are educated at law schools in America, and it's no longer teach much about the Constitution at all. They don't teach anything at all about the constitutional rights of fit parents. There are more than 50 U.S. Supreme Court cases over the last 6 decades about why and how the state cannot intrude into a parent-child relationship unless there's just cause, which generally means that the parent is some sort of imminent threat to the child. What Robert mentioned in his introduction is that Joe's not been accused of being any threat at all to any of his 3 children, who are named Harrison, Jacob, and Margot. Harrison's 6, Jacob's 5, and Margot's 3. And when this case started, when their mother filed for divorce in May of 2023, Joe was involved on a daily basis. He fixed their breakfast, he did their bedtime routine, engaged father, fit, loving father. This is a story that can happen to any man in America, and it does. And when a divorce is filed, the state of Virginia has a statute, and you may not be able to read it very well, but I put up on this whiteboard behind me the operative part statute that is supposed to benefit Virginia parents and children by requiring judges to take child custody issues up in a certain priority. Statute is Virginia Code 20-124-2. And I'm just going to touch on what the statute requires judges to do. And as I read this, just understand that in the case of the Sherman 3, as we call it, none of this has been done. Court shall provide prompt adjudication. And what I'm going to do is I'm going to read this provision, the operative parts, and I'm going to come back and touch briefly on what's happened or what's not happened. The court shall provide prompt adjudication upon due consideration of all the facts of custody and child visitation arrangements, including support and maintenance for the children, prior to other considerations arising in the matter. The Virginia legislature has tried to do is tell judges that as a matter of priority, when child custody is an issue, they want judges to take up and decide child custody as the first order of business in any divorce case, before other things are considered, and that they want a full and fair adjudication based on all the facts. So without getting too deep into the weeds at this point about the chronology of events in this case, let me just summarize it for you this way. Joe and his wife Caitlin were married in 2015. First child Harrison was born in 2018. Jacob was born in 2019, and Margot came along in 2021. January of 2023, Caitlin vacationed in Florida with one of the children, while Joe kept the other 2 at home in order to give her a break from all 3 children. After discovering some communications that told him that she was planning to divorce him at some point, they had a conversation about those communications, and on May 12th, 2023, Caitlin abandoned their marriage, took the 3 children with her, and moved to Accomack County. Joe didn't find out that she filed a divorce action until May 27, 2023, when he received a solicitation from a divorce lawyer asking if Joe would like him to be represented in the divorce action had been filed. And Joe wasn't served with the divorce action until later. In answer to the divorce complaint of Caitlin, because he's a successful, and I mean very successful, trial lawyer in Norfolk County Circuit Courts, Norfolk Circuit judges all recused themselves so that there would not be any perception that Caitlin was being treated unfairly in any custody order that they entered. So without entering any custody order, all the judges recused themselves. So from May, when the divorce action was filed, until August 31st, there were no custody orders, and Joe had almost no time with the children during that period from May, June, July, and August. So what the children experienced is they went from full-time dad, there every day, every night, frequent contact with his mother, or their paternal grandmother. She was a caregiver for the children from time to time. Instead of father and grandma being involved in their lives on a daily basis, suddenly there was father absence and grandmother absence for months. With no custody order in accordance with the statute that says it'll be a prompt adjudication, the Supreme Court of Virginia finally appoints a judge designate to hear the case on August 31st, 2023, and then Caitlin's attorney refused to set a hearing in September of 2024 for temporary custody orders, saying she wasn't available. The judge designate didn't set he decides to take the month of April. Well, this is a different part of the chronology. The judge didn't set the first temporary custody orders hearing until January 22nd, 2024. And so ask yourself, does that comply with the statute that says the court shall provide prompt adjudication? So he was appointed at the end of August of 2023, no custody hearing for whatever that is, another 7 months, till January of 2024. Meantime, Caitlin withheld the children almost completely from any contact with Joe. We're back to this disgusting tally that Robert shared with you of how many days Joe has had with the 3 children. And it is, in my opinion, it is state implemented child abuse to do with these 3 children what they've done to Harrison, Jacob, and Margot. You think the story doesn't get any worse, but it does. One of the standard radical feminist playbook plays to make is to drum up bogus charges of some sort of threat. And so just before the January 22nd, 2024 hearing, Caitlin and her attorney started pressing to have that hearing reset. They wanted to have it continued, and they wanted to kick the can down the road. It's no surprise to anybody that this father who loves and cares for and misses his children wanted to, refuse to continue the hearing. He was visiting on January 14th in Caitlin's home in Accomack County, and she staged what she referred to as a tussle. And he left, and then she called the cops. They came and did not make any charges based on her complaint. But she went down to the Accomack County Juvenile and Domestic Relations Court the same day and got an emergency protective order and filed criminal charges against Joe of assault and battery. And the whole story begins to get worse at that point because they didn't give Joe any notice of the protective order that had been issued. They set a hearing in the Accomack County Juvenile and Domestic Relations Court for January 18th, just before the Norfolk Circuit Court custody hearing on the 22nd, but they didn't tell Joe. Without notice of the Accomack County protective order hearing on January 18th, Joe no-shows, he didn't even know about it. They took the emergency protective order, made it into a temporary protective order, and then they go, after business hours, the day they got the protective order, and they notified Joe and his attorney that they've got a protective order against Joe, and they're gonna use it to reset the January 22nd custody order. And over Joe's objection, on January 22nd, the judge designate reset the January 22nd hearing, which is the first time that there had been any custody hearing. He just reset it to May 16th of 2024. So he kicked the can down the road another 4 months. Joe gets no contact whatsoever with Harrison, Jacob, or Margot. Without trying to drill too much deeper into the weeds, and I'm sorry for this chronology, but it's a horrific example of what happens on any given day, not only throughout Virginia, but throughout the United States, which is systemic injustice to the point of child abuse. And most people don't concern themselves too much about men and their feelings and so forth, but when you take a loving father who's been an integral part of his 3 children's lives, it is an incredibly destructive thing to suddenly remove those relationships. So don't underestimate what this does to a man. It's a miracle that Joe Sherman is still functional as a human being, much less as an attorney. And I'll tell you the kind of success, the true grit that Joe Sherman has is reflected in the fact that he's still representing clients. In this past week, I was told that he not only had a victory in the Virginia Supreme Court, but he got an appellate victory in the United States Court of Appeals for the 4th Circuit, which includes Virginia, which is the intermediate level appellate court before you get to the U.S. Supreme Court and the federal court system. So Joe has managed to sustain himself and continue to provide for his family, but as a result of these processes, seen his children less than 2% of the time over the last year. The only way the logjam was broken about the protective order was Joe had to file a motion again on what's known as an extraordinary writ, and the judge in Accomack County was served with a writ of prohibition and mandamus, requiring her to give him a hearing on the protective order because she refused to do so. Once that was served, he finally got a hearing. At the first hearing in Accomack County, at which he was allowed to present any evidence, the judge realized that she had been lied to by Caitlin and her attorneys about the basis for the protective order to include the 3 children. And so the 3 children were removed from the protective order, but over that 4-month period, it had been used as an excuse to give him no contact whatsoever. So he missed 2 of the 3 children's birthdays in that springtime. First opportunity that he gets to go have a visit with the 3 children, he takes his mother with him. He hasn't seen the children in months. He's missed 2 of the 3 birthdays. The 3rd child is opening his birthday presents, and Grandma takes pictures and video of that event, which is perfectly natural for anybody. A normal birthday, much less after no contact for 4 months. And there were no prohibitions in the conditions that no prior conditions saying that he couldn't have his mother there or take video photos. But Caitlin and the attorney went back to the Norfolk Circuit Court and complained about that, said that she had said that he had not been compliant with the conditions that she said, even though she didn't tell him that until afterwards. They basically removed the unsupervised visitation that the judge was going to give him as a punitive thing. And then they filed a motion for sanctions for other basis of complaint. The insult to injury is that at a recent hearing, Joe was ordered to pay on the order of $40,000 in Caitlin's attorney's fees as a punishment for what the judge said was plain, fast, and loose with the conditions that he had allowed Caitlin to set. There's a 2013, I think it is, Virginia case where the Virginia courts have said a judge abuses their discretion if they allow a parent to set the conditions of visitation of the other parent. And that's exactly what this Norfolk Circuit judge did. And so these issues are going to be before the Virginia Supreme Court in the petition for mandamus, which is asking the court to take original jurisdiction and order the Norfolk Circuit judge to give him a hearing. That's the most outrageous thing that's happened is, I haven't mentioned at this point, which is when Joe went to the hearing on May 16, 2024, expecting to be able to put on evidence and present his testimony and his case for what he proposed in the way of child custody and visitation, the judge would not allow his attorney to speak. That Jeremy Hopkins was told not to speak. So he was denied the effective assistance of counsel. And even though Caitlin and her attorney were allowed to put on evidence and testimony, Joe was not allowed to present his case at all. And then after Caitlin's testimony and evidence, the judge ordered the parties to do closing arguments. If there was ever a gross violation of the right to due process, it's to make a custody decision that affects both parents and the two children without giving one parent the opportunity to present any evidence. And what we're asking the Virginia Supreme Court to do is order this judge to simply comply with the statute 1-124.2, and even though there's no way he can make a prompt adjudication now upon due consideration of all the facts, and prior to any considerations arising in the matter, once that hearing is held, and it may not occur until the trial of this case, which is scheduled for August of this year, I believe it's August 15 and 16. May not get that hearing, but in the meantime, we're asking the Virginia Supreme Court to intervene and order this judge to follow the law. And then there is no question that this case will be taken up on appeal after the trial, no matter what the circuit judge does. Now, I've spent a considerable amount of our meeting time today talking to you about this travesty of justice. I don't want to take more time getting into the weeds, other than to say there's more to this story than meets the eye. This is just a textbook example. In fact, I'm thinking Jeremy Hopkins and I may write what's known as a case study. We're going to go through everything that's happened in this case and use it to illustrate all the harm and wrongdoing that has occurred. But you have to ask yourself, is this the court system, family court system of which the people of Virginia can be proud? Any remote semblance of justice, if not for Joe Sherman as a fit and loving father, and for Harrison, Jacob, and Mark, who no doubt wonder where their daddy is and why they don't get to see him anymore. So I think at this point what I'd like to do is offer to take questions or address any concerns that you might have, or I think I'd like to hear from the audience what they think and what comes to mind in this story. What do you want to know? What have I left out? I can assure you that record will reflect that even though Judge Joe was accused of being a marijuana abuser, that I think he's probably undergone 25 or 30 drug tests over the course of the past year, which shows that he hasn't had any drug use. And regardless of what you think about marijuana or alcohol, either one, there's not even an allegation that if he was using marijuana, that he was any threat of harm to the children. Adults can use those substances if it's legal, and I suppose Joe could do that, but during the past year he hasn't. So I suppose the worst thing you could say is that he's been accused of being a marijuana user, which has been untrue. It's actually proven to be untrue. He's been accused of being violent with Caitlin, which is just, the worst kind of smear on a man of integrity, but the standard feminist playbook is to make accusations which then linger like a stench over the whole process, because it's hard to get out from underneath a smear tactic like that. So it would be helpful to us as attorneys. Jeremy is listening into this presentation, and Joe will, I'm sure, be welcome the opportunity to meet or answer questions about this. But I'm open to any question anybody wants to ask, and I'd like that at this point.
Okay, Bill.
Thank you. We'll see if there are questions here, or would you like to make a statement?
No, I think it's
Wants to ask, she wants to ask the question.
What is the procedure for holding judges accountable for their actions? Is there any sort of, law or committee or something that oversees them?
Closer to the mic.
Did you hear me?
I heard the question. Yeah, I heard the question. What's the procedure or the mechanism for holding a judge accountable? There's a similar oversight in virtually every state. I can't speak with specificity of Virginia, but I'm confident that what I'm going to tell you is accurate. Every state has oversight of both attorneys and judges from different components of the state bar typically. So there'll be a grievance process that can be filed against this attorney for lying to the court, and we have documentation that she's lied in both the Appomattox Court and the Norfolk Circuit Court. But perjury is no longer a matter of concern to most judges. The Harris County courts, where my experience was in Texas when I was living in Houston, Texas, was publicly known and called in the newspaper the perjury palace, because it was a routine matter for people to get on a witness stand, take the oath that they weren't going to lie, or that they were going to tell the truth, and then lie through the tooth. And judges simply don't punish perjury anymore. So even though a complaint could and should be filed against Caitlin's attorney for lying to the court, which I think is not only unethical, but it's worthy of being disbarred, and herself is lied on the witness stand. And then as far as holding the judge accountable, there will be a comparable grievance process that can be filed against the judge to ask for the judge to be investigated, and then if there's due consideration and the facts are proven that the judge has abused their authority or their discretion, then they can be sanctioned and removed from office by the higher court, which includes the Supreme Court of Virginia. I don't know exactly what those mechanisms are in Virginia, but I guarantee you they're in place. In my experience, it's almost a complete waste of time to file a grievance against an attorney or a judge. The processes with which we should hope there's enough integrity to require accountability generally don't, in my experience. That doesn't mean that an action item for people in Norfolk County couldn't be to take this case up or this cause up and call for accountability through whatever that grievance process is for both the attorney and the ex-wife, or soon to be ex-wife, and the judge. I think the most disgusting thing in my mind, I mean, there's so many repulsive aspects of the facts in this case that the judge accepted the appointment as judge designate when he was appointed, and then at one point he took a month off while refusing to conduct a hearing on child custody. There's just excusable delay in my experience, and I think at some point it would be difficult for us to prosecute a grievance against any of these people while this case is open and we still haven't had the first hearing for Joe. So we're certainly, that's certainly on the table as something that we can and should do. I personally think that as an attorney, I have a duty to call out this kind of judicial and attorney misconduct, but now's not the time for us to do that as attorneys. We're going to try to get Joe a hearing, and hopefully the Virginia Supreme Court will see fit to to order this judge to give a prompt hearing where not only can Joe's attorney present all the constitutional challenges that have been heard one time, and this judge actually complimented the constitutional argument, but in the process of making commentary on it, said that in all the many years of, I think he said 35 years on the bench, he never heard a constitutional argument in court, even though it had been discussed, off the record and in chambers amongst judges and attorneys alike about the constitutionality or the lack thereof of the family courts in Virginia. So I'm sorry to not give you a very precise answer, other than to say that there is going to be some kind of mechanism by which a complaint against this judge can be made, and I fully expect that we will do that at some point, but not right now.
Thank you. I have a question that I'd like to ask. In situations, family court or child custody court, when one of the parents openly perjures themselves, and it can be demonstrated very soon after the perjury that it was a false statement made in front of a judge. That happens a lot. Do you know of any one judge who has ever subsequently brought perjury charges against that parent? Because I don't think so.
And I actually, and that's a failing that goes to the integrity of the entire system. If you look back all the way back to Mosaic law, and you look at references in the Bible to the application of the law, whether you refer to the Mosaic law or things that evolved out of that, it's all about truth and justice. You always see truth linked to justice. You can't achieve justice if you lie. If you seek a remedy or you seek judicial relief based on lies, you're perverting the entire process. And it should be punished. And I personally think it should be punished most aggressively in family court. As you know, the Supreme Court of the United States, in a case, a famous case called Foxer versus Granville, acknowledged that the parental relationship is the oldest fundamental liberty interest acknowledged by the Supreme Court of the United States. That probably is the most meaningful place anywhere in the law where personal relationships between parent and child and siblings in the same family are all drastically altered when one parent lies about the other parent. I think if there's any place in the law where we ought to handle people aggressively that lie to gain an advantage in litigation, it should be in the family courts, but that's the last place where it's enforced. I'm trying to remember what court I was in. I want to say it was in a case in Ohio that I was in called the Talk case. And I heard a woman who accused her soon-to-be ex-husband of domestic violence for which he was jailed, was on the witness stand, and the judge simply admonished her not to ever do that again. This man had actually spent jail time, and this judge did not punish her. In my opinion, that's the sort of admission on the witness stand that you lied and got somebody put in jail based on your false criminal charges. She should have been in jail within the hour on contempt of court and in criminal charges of perjury. And I don't know what the law is in Virginia. In Texas, where I was trained and where I'm licensed, perjury is a misdemeanor offense, but if it's done in open court, where you're under oath at a deposition or you're in a trial or otherwise under oath, that's an aggravated perjury, which is a state jail offense in Texas. The law's on the books, it's simply not enforced. And that's to our disadvantage, and it undermines and allows corruption in the system. If you simply cannot achieve substantial justice when the court's decisions are based upon lies. At this point in this process, in the case of the Sherman 3, the judge has really only heard one side of the story. There's a place in scripture, and I probably should have to check in verse where I could cite it, but it basically says the first to tell a story sounds good until the second comes forward to question. If you've ever served on a jury, whoever gets to present their case the first sounds pretty good until the judicial process of confrontation of witness and cross-examination and presentation of rebuttal evidence starts to happen, and then that initial story doesn't necessarily sound so compelling. So, we regret to inform you that if our courts would begin, simply tell people at the beginning of every family court case, much like a Miranda warning, if they would say, in this courtroom, and this is something I've said, I would love to hear a judge say it, I'm a man to whom the truth is important. And if I've got the black robe on and I'm going to decide the fate of children and their relationships with their parents, I'm going to tell both parties. I sit on this bench with the trust of the people of Virginia to adjudicate important relationship issues between parents and children. I'm a man and a judge to whom the truth is important, and if you lie in this court, you will be aggressively prosecuted for perjury, and I will put you in jail. When you get on this witness stand and you present evidence in any form, it had better be the truth. So if you want an action item that you can do, then get behind a petition demanding that perjury be something that is not given a pass in the family courts of Virginia anymore.
Hey,
Whether that petition
Cowboy, what I'd like to do at this point is shut down the Facebook Live, have you remain on Zoom so that Joe can speak to our audience here and answer any questions.
One last question.
Okay, and I apologize to our viewing audience on those of you who may not have received the notice of today's meeting because of the worldwide outage yesterday, and we only got sporadic emails, messages that went out. There's nothing I could have done about it, but it was all over the world. So apologize, and also I'm not slighting anybody watching this transmission, but we don't want anything that's going to prejudice Joe's next appearance in court. But we have one more question from Mr. Lindsay. David, could you come up here? Here.
Earlier, you said that you wanted to know if there was a rule that perhaps governed the judge's conduct. I think rule number 113.9 of the Virginia State Bar covers it. It deals with government attorneys, and is not a judge a government attorney. That's a prerequisite for him to have a job. And the rules very clearly say that they're to assure that the wrongful act is prevented or rectified. And the judges in these cases have not done either of those.
Okay, did you get all of that, Cowboy?
I got some of it. Some of it was clipped, but I heard the reference to the rule. I'll certainly take that under advisement. I appreciate you bringing it to my attention. One of the things that I'll be brief on this. One of the reasons this system has gotten less and less about truth and justice, and more about systemic injustice and money, is because attorneys don't aggressively pursue the remedies that are available in provisions like that rule. And at some point, we as attorneys are responsible for not keeping our own house in order. And I can assure you that before this case is over, I personally, if with or without the assistance of other counsel, will make the appropriate complaints at the appropriate time.
Okay, what I will do, I will have Mr. Lindsay pass that information on to Joe, and he can pass it on to you. And ladies and gentlemen, at this point in time, I'm just going to simply close out the Facebook Live portion of this broadcast, but Cowboy will stay on with Zoom, and the other gentlemen who can then be able to talk freely if they chose to do so. Thank you all very much for watching, and this will be posted probably tomorrow on my YouTube channel, Robert K. Dean. Thank you so much, everybody. Have a wonderful weekend.